scheduled in our in our program the online presentation by Mr. Nujat Parvin Khan, who is the Dean of the School of Law in Bennett University, India. The floor is yours. Please, would you please turn on your mic and
Your microphone, please.
we can't hear you. Would you please to? Yes, yes. Now we can. Now we can hear you. Okay.
To you all. Yeah. So, respected Professor Gavrilo, Dean and Director of the Far Eastern Federal University School of Law, Russia, Professor Natalia, Vice Dean on Research and Innovations, School of Law, Far Eastern Federal University, Mr. Shashi Bhushan, Consul General of India in Vladivostok, and all the esteemed co-panelists, colleagues, and participants. Thank you very much for giving me this opportunity to welcome you all to this sixth Pacific Law Forum on the topic Law, its application and implementation in the era of global challenges and changing reality. It is very important at the outset to discuss how law is placed within the society. Ideas, narratives, and schools of thoughts representing diverse backgrounds and origins help the society to develop. What matters most is what kind of values and norms it represents. But the values don't come to society by itself. There is always a strong, steady, and functional force in the equation. And this force distinguishing between calm and unrest, and that is known as the law. Now, when we talk of application, in application, the first significant role of law in any society is that it helps to maintain discipline and bring peace. The rule of law is a deterrent for any unlawful activity in a society. Next, the law in any society results in the formation of a justice system to safeguard the rights of its people and to resolve the issues. The law can tremendously bring the ratio of the crimes down through its effective strategies. And finally, the law does not just bring peace in the society for its change, but it also does so by playing the essential role of a mediator, which is happening nowadays in most of the countries across the world. I'm sure this forum will also deliberate on the broad areas of global challenges and the international law. Today, we are witnessing the rise of nationalist populism and extremist ideologies as the world becomes more multipolar but also more polarized. We have seen the impact of this trend on the multilateral agreements and the institutions. So we are seeing a growing disconnect between the people, the government, and the institutions, which is really something to be worried about. So unless these trends are reversed and resolved, there is a risk that they may damage the values, principles, laws, and systems that have been always the bedrock of the international community for decades and for centuries. And the irony is that these trends are occurring at precisely the moment when we need global cooperation more than ever. Given such uncertainty, the time is right to reaffirm key international norms, rule-based international orders, and to take the next positive steps to strengthen this order. Especially the given situation, the gravity of the global challenges now confronted decision makers should be ambitious in contemplating recommitment to core United Nations Charter principles. There have always been substantial achievement in the sphere of rule-based international order, but there is undoubtedly more work to be done. So, with this brief outline, I welcome you all once again and congratulate the university for organizing this timely forum. I look forward to the discussions and presentations by the participants during the whole day. I particularly thank Professor Natalia for giving me this opportunity, and the Bennett University hopes to collaborate further with the Far Eastern Federal University School of Law, Russia. Thank you very much.
Thank you very much.
Thank you very much, Professor. And thank you for the...
We will have all kind of possibilities to cooperate in the nearest future. Thank you for your participation. Thank you very much. Дорогие друзья, еще одним нашим давним партнером является...
Your friend, one of our long-time partner, is the Uncitral in the United Nations Regional Center for Asia and the Pacific, and gives me a pleasure to give a floor to Miss Atita Kamindar, who is the head of the Uncitral RCAP.
Presentation prepared, so I will share my. I hope you can read. Dr. Vyacheslav Gavrilov, Dean of Federal University of Law, distinguished speakers and participants. Greetings from Incheon, Republic of Korea, and the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific. It is an honor to join the plenary session of the 6th Pacific Law Forum, with special thanks to FIFU for the kind invitation and seamless virtual organization led by Dr. Natalia Pisakina, Vice Dean of the School of Law. The work of the United Nations and Uncitral perfectly illustrate today's plenary session on law, its application, and implementation in the era of global challenges and changing reality. As noted by the Legal Council of the United Nations, international cooperation and international law are mutually indispensable and naturally require an inclusive and networked multilateralism as their framework. When world trade began to expand dramatically in the 1960s, states began to realize the need for a global set of standards and rules to harmonize and modernize the assortment of national and regional regulations, which until then largely governed international trade. They turned to the United Nations, thus leading to the General Assembly establishing Uncitral in 1966. Uncitral has since then become the core legal body of the United Nations system in the field of international trade law. Uncitral rules are negotiated and endorsed by member states representing different legal traditions and levels of economic development. If it's just one country's system, it won't work. The mandate of Uncitral thus highlights the promotion of the progressive harmonization and unification of the law of international trade, and was designed to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. To promote and achieve legal harmonization, Uncitral issues legal instruments endorsed by states, which they use to support their commercial legal environment. These legal texts can take different forms, such as conventions, model laws, and legislative guides, and cover the life cycle of businesses for commercial transactions, ranging from business registration, including simplified incorporation for micro, small, and medium-sized enterprises, to e-commerce and sales, access to credit and financing, dispute settlement, and insolvency. All Uncitral texts are published on the Uncitral website in the 6 United Nations languages, including Russian. For ease of reference, the general coverage of Uncitral text is displayed here in Russian, along with the relevant web link. To promote the use, adoption, and uniform interpretation of Uncitral texts, the Uncitral Secretariat undertakes 2 other main activities: the provision of technical assistance and capacity building, along with the collection and dissemination of information on developments in the field of international trade law. In the Asia Pacific, Uncitral promotes legal harmonization in international trade and commercial law via my office, the Uncitral Regional Center for Asia and the Pacific, or Uncitral RCAP. RCAP is Uncitral's only regional center and is located in Incheon City, Republic of Korea, opening our doors in 2012 with the support of the South Korean government. Uncitral RCAP's activities range from organizing briefing missions for government agencies to assisting international development agencies in using Uncitral texts in law reform projects, to participating in conferences like this one to raise awareness of and familiarize public and private stakeholders with Uncitral texts and their use. Cumulatively, since RCAP was established in 2012, the majority of Asia-Pacific jurisdictions under our coverage have adopted at least one Uncitral instrument, greatly contributing to legal harmonization both regionally and globally. These actions cover a comprehensive span of Uncitral areas ranging from e-commerce to dispute settlement. Other areas not shown here include contracts and sale of goods, insolvency, and transparency in investor-state dispute settlement. For participants interested in learning more about Uncitral, I invite you to join the Regional Center's events throughout the region, especially our shown flagships on your screen, most of which are virtual and open to the public free of charge. Many events this year focus on how legal harmonization could assist the economic recovery of micro, small, and medium-sized enterprises, particularly in the wake of COVID. I would also like to highlight the upcoming Judicial Summit co-hosted with the Department of Justice of Hong Kong, China, which will cover such interesting topics as green financing, dispute resolution in the digital economy, insolvency, and the United Nations Convention on Contracts for the International Sale of Goods. We invite you to join the event from 1 to 2 November next month. Last but not least, please peruse the Uncitral RCAP webpage and subscribe to our mailing list via the QR code for information on Uncitral developments and RCAP activities. Thank you again to Far Eastern Federal University and all the organizers for this privilege.
Thank you very much, Atita, of course, for cooperation, for the understanding how your excellent organization is working in the modern Northeast world. And we will continue our future joint cooperation in different kind of areas. Thank you very much again. И в завершение пленарной части приветственных выступлений я с удовольствием предоставляю слово.
I would like to give a floor to Consul General of India in Vladivostok, Mr. Shashi Shoshanu, for his welcoming address.
Okay. Spasiba Balshoy. Good morning, everyone. Dear Mr. Alexei Consul, Acting Rector of the Far Eastern University, Mr. Vyacheslav Gavilo, Director of the School of Law, Ms. Natalia Prespina, Vice Dean of the School of Law, distinguished guests, and the participants from different countries. It gives me immense pleasure to address you today at the 6th Pacific Law Forum, titled Law, Application and Implementation in the era of global challenges and changing reality. The forum has been attracting scholars not only from the Pacific countries, but from across the world to discuss, debate over the problems in the globalized world. Today, the world is faced with many challenges like global warming, nuclear arms race, regional domination, data privacy, and terrorism, to name a few. These challenges are impossible for a country to fight on its own. The role of law, specifically the international law and its various domains, become pertinent in addressing these challenges. How to draft a law which treats like alike and ensures compliance even by the strongest countries on the earth. Various attempts like Paris Climate Deal, various arms control mechanisms, Convention on Terrorism, etc. could not succeed. The role of international law is crucial in ensuring that the legal aspects are acceptable to all and a strict enforcement of these could be ensured from the sovereign countries. I'm glad to see the kind of participation in today's forum. Many of the experts are presenting their papers on above mentioned topics today. It would be a great learning experience for me. And I once again take this opportunity to thank the organizers of today's forum for inviting me to speak at the inaugural address. I wish all the participants success and hope that we all can leave today more enlightened and knowledgeable after today's session. Thank you.
Thank you very much, Mr. Consul General. We have several presentations from participants from India today, and this is a good sign and a good and a good promise for continuation of our cooperation, because India is a very interesting and our long-term partner. We are very interested in cooperating with India in various aspects, in culture, in science, and other. And now, by thus, and other areas, and I would like to announce the continuation that we are going to start our report and presentation. I would like to start, and it gives me immense, great pleasure to give a floor to President of Far Eastern National, former President of Far Eastern National University, Honorary Doctor of Far Eastern Federal University, the long-term Dean of the Law School of Far Eastern Federal University, Honorary Citizens of Vladivostok, Busan, Tajin, Honorary Doctor of Universities of the U.S., Japan, Republic of Korea, member of China, member of International Commercial Expert Committee of the Supreme People's Court of the People's Republic of China, the man who stood at the formation of the legal education in the Russian Far East. It gives me pleasure to give a floor to Dr. Vladimir Kurilov. Oh, thank you very much, Dr. Gavrilov. Dear colleagues, all colleagues who work in the law school and who are supporting the legal education in the Russian Far East and legal education in Far Eastern Federal University. I'm going to talk about the issues which are of keen interest for legal experts, for academics, for scholars in law, because law is a very influential in all spheres of humankind activities. We've heard the presentations from India, who is going to become soon the third economic power. China has already become the second economic power in the world, and Russia is very interested in law to become the more and more influential in various spheres of social and economic life. And first of all, I would like to talk about the human rights and about the development of economic cooperation. Dear colleagues, the modern world and growth of global population are in a state of change with an acceleration which often does not allow to fully foresee the opportunities and risks in ensuring the implementation of the functions of law and creating appropriate response related to regulatory development. In the theory of law, its functions were defined as main directions of legal impact, expressing the role of law in the harmonization of social relations. This definition impoverishes the concept of the function of law, which should not only streamline but regulate public relations or exercise legal pressure on them in order to achieve a clearly defined result. Law, we know that law can affect public relations in three ways: keep pace with their development, lag behind the needs and the state of social relations and hinder their development, stimulate the development of public relations, creating such legal arrangements that ensure the progress of public relations. The classical theory of law has established four main proper legal functions: regulatory, protective, educational, and evaluative. Without denying this postulate, the fifth function should be added to them: the function of stimulation, which means that the law does not simply establish the rights and obligations of the subject, but creates with the help of legal means the models and forms of legal behavior of subject and social relations necessary for the state and society. The development of economic and social labor relations is associated precisely with the use of legal methods to stimulate subjects and the development of certain social relations. The implementation of the functions of law should be inextricably intertwined with the study of the effectiveness of law, which is understood as the correlation between the goal set when adopting the rule of law and the result achieved. It is a fatal gap in research on the effectiveness of law that explains the failed experiments to criminalize or decriminalize criminal acts, specifically in tax, civil, or labor law. In modern legal science, research on the effectiveness of law is extremely insufficient. Also, following the path may highly likely lead to improving the quality of work not only of the entire legal system of the state, but also increase the level of protection of the subjective rights of the state, increase GDP and growth in labor productivity. Insufficient attention to the need of legal regulation and its effectiveness is demonstrated that we witness then law lagging behind the needs of light when a legal vacuum emerges where regulation is necessary but was not arranged by the legislator. A typical example is the situation with electric scooters, which not only caused serious damage recently to the health of a number of citizens, but also entailed damage to law and order and the legal consciousness of citizens. The same applies to the phenomenon of lynching, which we've recently seen in some parts of our country. Modern law, including that of Russia, lags behind the new requirements, especially in the context of artificial intelligence development, information technology, scientific and technological progress. Transformation of human beings is slowly but steadily gaining signs of cybernetic system. On this basis, the social norms that should underlie the law are changing, namely the norms of morality, ethics, customs, etc. The regulatory role of the moral and ethical norms is catastrophically depreciating, and customary law, including those lying in the area that famous scientist, legal scientist Alexeyev called the infra-law, is changing towards the ever-accelerating departure from the principles of justice and humanism of law. Total computer monitoring, a face recognition system, illegal video cameras, the impotence of criminal law in combating cybercrimes, decline in the functioning of labor law, a sharp decline in the protective function of labor law, as specifically when we talk about individual subjects of international relations, that the law in the modern society is lagging behind. If this conclusion is even partially correct, then the protection of the natural rights of the individual as well as the protection of the legitimate interests of the state and society will be carried out less and less effectively. If the law, I would like to remind you on the futurology of the Google Chief Technology Officer Ray Kurzweil, a renowned futurist who predicted that laws governing the relationship between human and robots will be passed in the United States and Europe as early as 2022. The activities of robots, their rights, obligations, and other restrictions will be formalized. By 2027, it is expected that personal robots will be capable of fully autonomous complex actions. And by 2029, the computer will be able to pass the Turing tests, proving that it has intelligence in the human sense of the word. This is supposed to be achieved through a computer simulation of the human brain. By 2038, robotic humans equipped with additional intelligence are predicted to appear. And the activities in this area are underway. By 2044, Kurzweil predicts the creation of non-biological intelligence billions of times more intelligent than biological. Looks unbelievable, but by the way, all computers in the world are equal in power to the human brain. As noted above, the human right to an honest life is put at serious risk under the influence of the accelerated development of total control. Hundreds of millions of video cameras, selection and creation of DNA bases, wiretaping, videotaping of private human life, it's through smartphones and other technical means. The society has the right for protection. The risks of terrorism are increasing nowadays. Now a small group of people can create weapons of mass destruction practically at home. Back when a nuclear bomb was invented in the United States, more than 40,000 scientists from all over the world were recruited. I'd like to remind you that a small group of people can create that back in 1969, a group of biologists was convicted in Boston for cultivating a virus capable of destroying all humans. The subjective right to protection of the state and society can be guaranteed in this respect only by strengthening control. And thus is very important for these security issues, and in the context of pandemic, there is a need for a new study in legalization of many other threats and risks to the constitutional rights. Modern scientists and politicians know that the purposeful development of anti-Russian xenophobia by forces are conducted by forces to a country. A real war is going in this area. But the state and society have constitutional right to protect the truth, and they're interested. And in many countries of the world, the protection measures are very strict. For example, according to the law of State of Israel, an anti-Semite noted in any country will be banned to enter the territory of the State of Israel. This is a law. So it is necessary to support the draft of federal law on counterfacing of anti-Russian Russophobia submitted to the State of Duma. Russia is a great power, and Europeans who are trying to protect their children from so-called early sex education in schools and the imposition of LGBT ideology on them, we clearly realize the significance of Russian constitution and traditional family values in EU. Countries like Hungary or Catholic Poland are severely fighting for their right, despite the financial economic sanction, to protect their families' values. In the Eastern Union, they deal with the sensitive issue of the relationship between the legal force of national constitutions and EU directives. In new edition of the Constitution of Russia, these problems are resolved in favor of the people and the state. However, there is an area in the development in which the law has not yet set its proper word. In 2021, the U.S. share in the world GDP is 24.4%. China's economy is estimated at 11 trillion, almost 12 trillion US dollars, takes 15% of the world GDP, and is the second after the United States. Russia's contribution to the global economy is 3.2% according to 2018. If we evaluate GDP in terms of purchasing power parity, then China's GDP is higher than that of the United States by 9.1%. According to this indicator, Russia is in 55th place in the world. Also, the post-pandemic GDP growth rate in Russia is now 5%, and the country's economy has recovered to the pre-pandemic level. It is clear that a new powerful impetus is needed for the country's economic growth and increase in labor productivity. And in this respect, law should not register the decisions of economists, but should itself initiate effective legal solutions for economic problems. As you know, statistics is a tricky business, and the numbers can change when the calculation methods change. However, there is no doubt that the U.S. economy is losing its position, and the Chinese economy is taking the first place, and the third will be India. China's economy, even in the context of the pandemic, for the first half of 2021 showed GDP growth rate of 12.7%, while an average annual growth rate of the world economy planned for 2021-2025 was 4.1%, but actual figures are low. There are many examples of powerful economic growth in the history of Russia. Russia is able to make an economic stride. For example, at the beginning of the 20th century, the growth rate of industrial production in Imperial Russia was higher than in the United States. For 25 years, from 1891 to 1916, the Transsib Railway was built, the cost of which at modern prices was 75 billion US dollars. The USSR was one of the two superpowers in the world and implement economic projects that won wonder and admiration after the great victory in the war against fascism. In 1945, the USSR had 170 destroyed cities, 65,000 destroyed villages, and 73,000 collective farms and state farms, 10 million handicapped people, 25 million homeless. And only after 12 years from that time, the USSR was able to launch the world's first artificial Earth satellite, and 4 years later, Yuri Gagarin became the first cosmonaut in the world. But as a result of the collapse of the USSR and the shock therapy reforms of the young reformers in 1990s, Russia lost about half of its economic potential. But starting from the new century, Russia was able not only to restore the economy, but also achieved new development, as a result of which Russia became one of the 6 strongest economies in the world. Nowadays, Russia is coming to a next stage of its economic development breakthrough. So, on the one hand, it is necessary to abolish outdated, ineffective legislation, which will help to improve the activity of the subjects of economic relations, as well as bring new meanings to the methods of permissibility in regulating the economic relations. In modern history, China has shown a great example to the whole world. China, being a developing country, according to the U.S. rating back in 1990, was able to reach the level of the second economy by 2015. This phenomenon became a subject of separate comprehensive investigation. However, the PRC put a stake on getting rid of excessive legal regulation of economic relations, especially in the field of small and medium-sized businesses. It should be noted that 70% of jobs and 50% of all innovations are created in the PRC at this level. It's interesting to know that the problems in the economy, including the crisis of 2008 and subsequent years, were solved not by increasing taxes but by maintaining and increasing the purchasing power of the population and reducing taxes for business. So in 2018, VAT was reduced from 16 to 13 for businesses, and in construction and transport from 10 to 9. At the same time, Chinese experts have calculated that tax cuts not only help to retain the revenues of the country budget, but also allowed businesses to increase the profitability of the enterprises by 40%. In 2021, the PRC started to fulfill the 14th five-year plan under the innovation and technical independence slogans. Increase the funding for fundamental scientific research and started to attract investment from both state budget and market focus. So fundamental scientific research has become the visible productive force. President of Russia, Vladimir Putin, in one of his recent report, noted that most of the Chinese R&D developments were achieved on the basis of Russian R&D, of Soviet R&D results. That's are the key principles which were voiced out at the 19th Congress of this Communist Party of China. A number of measures to support enterprises in the market have been implemented. The number of these enterprises is over 130 million. China has significantly simplified administrative procedures for these enterprises by optimizing public services, by strengthening the confidence of business stakeholders. New architectonic under the principle of double circulation was established, which provides that the main thing for the economic development is demanding demand, while also providing opportunities for foreign investment to be active. A double circulation strategy protects the Chinese economy from the potential crisis in the global economy. Government support for businesses, tax minimization, new tax incentives, reduction of the refinancing rate and loan fees by banks, measures to combat poverty are accompanied by appropriate legislative provisions. It's very often the voluntary donations on behalf of millionaires and billionaires from China are also involved. The Russian legal science have to research on this issue and the prime source of social wealth is labor. The organization and use of labor in the Russian Federation regulated by labor codes adopted by the State Duma on December 21, 2001 and approved by Federation Council on December 26, 21. In accordance with Article 1 of the Labor Code of the Russian Federation, the goals of labor legislation is to establish the labor rights and freedoms of citizens, create favorable working conditions. The main task of labor legislations are to create the necessary legal conditions for achieving optimal coordination of the interests of the parties to labor relations. Optimal coordination of the interests of workers and employers, always, as Karl Marx wrote about in his work Capital, rests against the contradiction between labor and capital and cannot be absolute. The required optimality is determined by politics, economics, the interests of the parties in labor relations, and the employers, the state and society are interested in increasing the productivity of workers, which depends on scientific and technical support and labor qualifications and the level of exploitation of workers. At the same time, it's clear that the employer is interested in increasing labor productivity at the lowest cost. In the pre-crisis 2019, labor productivity in Russia increased to one average of $30.3 per hour, with the usual level of 26.4, which is about half of it, or even 3 times lower than in the developed economies of the world. For comparison, in the United States, this figure stays at $77 per hour. Russia's place in terms of labor productivity with different counting systems from 34 to 52 in the world due to the difference in calculation methods. Even the second economy in the world, China, in some cases is given 58th place and sometimes 78th place. The leaders of various ratings are Ireland, Norway, Switzerland, Luxembourg, Germany. Why the Ireland is the best? The reason include a high level of digitalization of the economy, high quality workforce, and international financial transactions activity. Norway benefits from the fuel and energy complex. Qatar, due to the volume of high-quality oil. In 1983, labor productivity in the USSR reached almost 53% of the U.S. level. In 2019, according to the OECD, Organization for Economic Cooperation and Development, Russians worked 1.9 hours a year, while people in developed countries 1.7 hours. At the same time in Russia, according to Russian statistics agency, the average salary for 2019 was 9,000. In OECD countries, this figure was 48,600 per annum. At present, Russia, within the framework of the scientific project Labor Productivity, a number of measures have been taken for technological renewal, training of workers, and the elimination of outdated and redundant legislation. For example, Part 2 of Article 91 of the Labor Code of the Russian Federation establishes that the normal duration cannot exceed 40 hours per week. In this case, the procedure for calculating the standard working time is determined by the federal executive body, and the employer is obliged to keep track of the actual time worked by each employee. This rule is often violated like other labor law norms. The death of workers from overwork has been increasingly observed. And not only in Russia, but in the United States of America, Japan, China, and other countries. Overworking results in the increasing amount of suicide. The risk of stroke increases by 300, and the risk of heart attack increases by 25%. Elon Musk tells his employees to work like hell. At the same time, research by scientists from the Stanford University shows that only 4 working hours a day in the most effective way. And a 4-day working week gives an increase in labor productivity by almost 50%. Recently, the president of the Russian Federation, Vladimir Putin, said that the main enemy of Russia at the present time is poverty. And it is indeed, according to statistics, 17 million people in the country have an income below the subsistence level. 23% of children in Russia are brought up in low-income families. 14.7% of the residents of Primorsky territory have an income below the subsistence level. Legal methods are needed for stimulate this creative ability of the individual to work at the limit of the methods of coercion cannot solve this problem. Increasing the socio-economic efficiency of law. The implementation of its functions require relevant research and new legal solutions. The law is lagging behind. The law must overcome this lag. Thank you very much. Thank you very much, Dr. Kurilov. The next speaker is the Chief of the Protection Policy and Legal Advice section in the Division of International Protection at the UN High Commission for Refugees, Ms. Madeleine Garlick. She's going to talk about legal considerations related to forced displacements in the context of climate change.
Мне очень приятно и почетно участвовать в этом онлайн-мероприятии на тему права.
My name is Madeleine Garlick. I'm Chief of the Protection Policy and Legal Advice Section in the Division of International Protection of UNHCR, the UN Refugee Agency. One of my division's key areas of responsibility relates to the development of legal guidance on the interpretation and application of international refugee law. UNHCR develops such guidance on the basis of its mandate conferred by the UN General Assembly. UNHCR's mandate includes a duty to supervise the application of international conventions for the protection of refugees, including, at a global level, the 1951 Convention relating to the status of refugees and its 1967 protocol, as well as at regional level, the 1969 OAU Convention governing the specific aspects of refugee problems in Africa. This protection mandate applies in all situations throughout the world, including, but not limited to, climate change and disasters. I'll now move to share my screen to provide some slides which will form a backdrop to my remarks. So climate change and disasters are affecting the lives of millions of people around the globe. The most recent report from the Intergovernmental Panel on Climate Change has been referred to by the UN Secretary General as a code red for humanity, impelling us all to urgent and more resolute action. The adverse effects of climate change and disasters are increasingly contributing to human movements in the form of planned relocation of individuals or communities, migration, leading to the voluntary movement of people, or are leading to displacement, forcing people to leave their homes or even seek protection in other countries. Climate change and disasters act as threat multipliers, adding to already prevailing stressors in a society or pre-existing vulnerabilities of people, exposing them in some cases to serious harm or human rights violations, or indeed to existential threats, for example in the form of disappearance of small island states. While the relationships between climate change and human mobility is complex, it is clear that climate change intensifies existing vulnerabilities of many people. Some of them may, as a result, be compelled to leave their homes, most frequently within their own countries, but sometimes even across borders, as they are forced to flee dangerous situations or conditions where it is no longer possible for them to live in safety. Displacement in this context is always multi-causal. Extreme weather events, environmental degradation, and social, economic, and political factors often interact and exacerbate each other, sometimes leading individuals or societies to reach a tipping point. Heightened vulnerabilities intersect with other risk factors, including natural hazards, conflict, socioeconomic conditions, and multiple forms of discrimination. Paragraph 8 of the Global Compact on Refugees, affirmed by the UN General Assembly in 2018, recognizes that, whilst not in themselves causes of refugee movements, climate and environmental degradation and natural disasters increasingly interact with the drivers of refugee movements. This reflects the way in which climate change and disaster can impact on refugees and trigger or exacerbate the causes of their flight. Given its protection mandate, UNHCR works to ensure that people affected and displaced by climate change and related disasters are properly protected, particularly when they flee to other countries in search of safety, and that existing legal instruments are correctly interpreted and consistently applied. Acknowledging the impacts of climate change and disasters on human rights and the displacement and protection needs they trigger, UNHCR has developed a comprehensive strategic framework on climate action. This includes 3 pillars. One, on legal and policy issues, including normative aspects for the protection of people when displacement occurs in the context of climate change and disasters. one on operations, focusing on disaster preparedness and early warning, seeking also to ensure that UNHCR supports protection and rehabilitation of the environment and displacement situation, enhancing resilience of people displaced, and strengthening preparedness and responses. And a third pillar on reducing UNHCR's environmental footprint and greening UNHCR's operations. I'll turn now to speak in particular about this first pillar on law and policy. The focus of this policy is threefold, including action on interpretation and guidance on the application of refugee and human rights law and policy frameworks to protect displaced and stateless persons. Secondly, engaging in policy dialogue, trying to help ensure that vulnerable people and protection are central and reflected in discussions between states and amongst international organizations to recognize the scale of the risks and to focus on action. And thirdly, research and analysis in order to work together with partners to deepen knowledge on protection for people and inform policy and decision making. Under this workstream, UNHCR provides guidance to states and other partners on the application of existing refugee law instruments for protection of people displaced across borders in the context of climate change and disaster. In October 2020, UNHCR published legal considerations regarding claims for international protection made in the context of the adverse effects of climate change and disasters. This paper builds on past UNHCR work that has been conducted in the frame of the Platform on Disaster Displacement in implementation of the Nansen Initiative agenda for the protection of cross-border displaced persons in the context of disasters and climate change. And it builds on UNHCR's 2017 legal considerations on refugee protection for people fleeing conflict and famine. It also draws on a 2018 UNHCR study entitled In Harm's Way that looked at state practices in Africa and the Americas in providing international protection for people displaced across borders in situations where conflict or violence and climate change or disasters interact. This paper has been developed in close cooperation with academics, legal practitioners, judges, and other partners as part of UNHCR's role in providing guidance on international refugee or law instruments and their application. UNHCR's analysis in the paper highlights that addressing the diversity of climate change-related issues and their impact on people's lives is a collective responsibility requiring action by all concerned through a holistic approach, recognizing that in the first place, mitigation and adaptation to climate change and related risks are of utmost importance to prevent displacement from occurring in the first place. Recalling that there is no such category as climate change in international law, and without seeking to expand the scope of the refugee definition in international law, the paper nevertheless notes that there are circumstances where international refugee law and human rights law may apply. Based on a legally sound interpretation of the criteria in the refugee definition, as well as regional instruments, people displaced across borders in the context of climate change and disaster may have a well-founded fear of persecution or be compelled to seek refuge abroad. This can occur in particular where climate change acts as a threat multiplier in situations where human rights are at risk, where the state is unwilling or unable to provide protection. The refugee definition in the 1951 Convention applies to people who have a well-founded fear of persecution based on reasons of race, religion, nationality, membership of a particular social group or political opinion. Such people will require international protection where their countries of origin are unwilling or unable to protect them from such persecution and where they have been forced to leave that country as a result. When assessing protection needs in the context of climate change and disasters, those effects cannot and should not be looked in isolation. The effects of such natural hazards, including drought, flooding, and cyclones, frequently add to already prevailing problems in a country, society, or community, such as poor governance, undermining public order, scarcity of natural resources, fragile ecosystems, demographic changes, socioeconomic equality, xenophobia, and political, social, or religious tensions. Such situations can often lead to human rights violations, conflict, and violence. As a result of the effects of climate change and their interaction with these other factors, combined with other vulnerabilities, people may be forced to leave their countries of origin and seek protection or asylum in another state. It is thus often not possible nor necessary to focus on the human component in such contexts. Therefore, when an asylum decision maker considers an asylum seeker from a country affected by climate change or disasters, the decision maker should not focus narrowly on the climate change event or disaster alone as an isolated natural phenomenon or hazard, but should consider how it was and continues to be handled by a state, and what effects it has on society and on the well-being and enjoyment of human rights, and on people and distinct populations and communities. This human dimension may bring the person within the definition of a refugee, where the risk of persecution on one or more of the grounds listed in the 1951 Convention are present, and where the state is unwilling or unable to protect. Beyond situations where the 1951 Convention may be applicable, the legal considerations highlight that people may also be refugees under the broader refugee criteria outlined in the 1969 OAU Convention relating to refugee problems in Africa, as well as the 1984 Cartagena Declaration on Refugees that has been endorsed widely by states in the Americas. Those instruments contain a wider definition of a refugee, which encompasses people who are fleeing events seriously disturbing public order, which can notably include situations where climate change and disasters result in such disorder and may compel people to flee. The principle of non-refoulement and other instruments of international human rights law may also apply to people seeking international protection and emerge as particularly relevant in countries where regional refugee definitions are not applicable. If a person has been displaced by the effects of climate change, where there is a real risk of being subjected to serious harm upon return, affecting their lives or amounting to ill treatment, that person needs to be protected from return in accordance with the prohibition of refoulement. This can bring them within the scope of complementary forms of protection that are recognized in UNHCR's legal considerations. The Human Rights Committee, in its 2020 decision of Odr against New Zealand, recognized that the adverse effects of climate change and disasters can pose a serious threat to the enjoyment of the right to life. For example, because of increased scarcity of habitable land, limited access to potable water, and the lack of alternatives to subsistence. Temporary protection may also play a role in situations where sudden onset disasters, such as floods or hurricanes, may affect a population, and where people may flee across a border, and there is a temporary period during which their state is unable to protect them. And states are encouraged to afford such temporary protection to those who cannot return for that temporary period of time where relevant. The risks facing people forced to flee in the context of climate change and disaster are not something that UNHCR or the UN can address alone. It requires global collective engagement. Given the nature and magnitude of the phenomenon, and while recognizing that UNHCR has a unique protection mandate, efforts are needed on the part of actors worldwide, including states, other UN agencies, NGOs, academics, and individual experts. UNHCR works with all of these sectors, seeking to advance knowledge and better understand the protection environment for people affected by the impacts of climate change, and to seek better answers to the problems. More efforts are needed to mitigate the risks in most climate vulnerable countries and regions and adapt to the effects of climate change, as well as building resilience to enable people living in those countries and regions to withstand risks and therefore avoid displacement in the first place. Beyond this, we need to work to ensure that the existing refugee and human rights instruments are effectively used to protect people when displacement occurs. This is an important part of addressing one of our world's greatest and most pressing challenges. On behalf of UNHCR, I'd like to thank again the organizers of this event for the opportunity to join you and to wish you all the very best for fruitful discussions in the days ahead. Thank you very much.
Dear colleagues, I would now like to give the floor to present the Dean of School of Law, PhD in law, Mr. Gavrilev. Dear colleagues, I would now want to speak about a very important topic, which is focusing on what contemporary law is in general and what are the opportunities for its development. It's no secret that the world is undergoing a tremendous technological transformation. The development of digital technologies and other means of virtual interaction has seriously complicated the traditional concepts of social communication. Numerous economic and social indicators evidence this. Just think about it. Today, the internet is used by almost 60% of the world's population, which is 4.66 billion people. In 2020 alone, the number of users has increased by 7.3%. 4.2 billion people have accounts on one or more social media. In Russia, the number of internet users today has increased to 124 million people. At the same time, they spend time there working, relaxing, almost in a full day, which is 7 hours and 52 minutes. 7 hours and 52 minutes. One of the key features of the digital era is that many companies provide information goods with virtually zero storage, transportation, and replication costs. Therefore, many contemporary technological giants such as Instagram and WhatsApp, in order to enter the wide market, did not require a lot of funding. In other words, thanks to a new type of technology, the role of classical capital as a fundamental basis for creating and running a business has completely changed. The very content of these concepts has also changed, which leads to a significant difference between the modern economy of a new type from the previous one. These changes could not affect the state and the legal sphere, where qualitative and quantitative digital transformation are taking place. New models of government interaction in the framework of individual, society, state system began to form, among which, in particular, are digital services, of delivery of services, various options for e-government, social rating systems, etc., which deserve special attention. In fact, the very notion of the subject of law has changed, in which fundamentally new actors are running the show, such as our online communities, hybrid political entities such as avatars, digital copies, virtual agents, and actors. We now have such actors as actants, automated digital algorithms, artificial intelligence systems, self-learning neural networks, algorithmic expert systems, and so on. Today, we should consider all this not just as an object of promising lawmaking, but as a given, which de facto has a serious impact on the functioning of the legal system we are used to, which dramatically transform the legal system of the world we are used to. As a result, more and more specialists and experts are paying attention to the need to establish legal form of regimes that are adequate to modern digital realities, which improve legal technology and advanced legal modeling of public relations. The latter is especially significant in the aspect of the emergence of multiple practical challenges, such as, for example, the problem of regulation of supranational digital spaces, when social community giants from one country make an impact on the other ones, emergence of and registration of new subjects of law, implementation of human rights in the digital space, and many others, which emerge almost daily. I believe that there is little sense in this report to talk about specific problems and to try to figure out how to solve them here and now. We consider such an approach to this something akin to patchwork rulemaking.
Today, the patchwork rulemaking is more likely to hinder the whole process. And first of all, we need to recognize that we need to solve all our problems from doctrinal and methodological points of view. We need to recognize the fundamental difference between the modern legal paradigm of the world from the one that existed only recently in the 20th century. If earlier legal thinking was based on its own methodology, will, interests, now it is necessary to include the laws of new virtual states of a person in the legal agenda. What in the past was considered inanimate and was a priori just an object of legal relationship, today is becoming part of human life. And most importantly, the basis of new relationships. It's again about gadgets, avatars, AI, etc. Traditional law, with its classical methodology, will not even consider such legal relations because they lack the necessary subject composition and an understandable familiar object of legal regulation. In other words, today we need not just a change in the content of the norms of positive law, for example, the creation of new institutions or norms with digital grounding, but the introduction of new concepts and categories based on the specifics of the modern technological space, which has the feature of self-regulating normativity and independently synthesizes images of behavior of participants in new social relations. There is every reason for such statement of the question, since the changes that have begun to transform the usual classical legal picture of the world are obvious. This is confirmed in particular by the fact that today the volume of non-state legal regulation in the version of living contractual law by Eugen Ehrlich understanding critically exceeds the traditional positivist one. Thanks to digitalization, we are witnessing some signs of the sociological renaissance in law, which we may call exterritorial legal systems, such as online transnational platforms, Amazon, Alibaba, Google, Facebook, etc. Within the framework of such systems, a new high-quality organized legal type regulation has been formed, completely abstracted from the state with its system of formalized enforcement. Interim measures in such systems are completely technologically based or technology-driven. So what do we have? Quite a paradoxical picture, the continuation of existence of the old law in the new world. The law, which, as Dr. Vladimir Kurilov correctly noted, is lagging behind, or rather, forgive me for this metaphor, is rapidly lagging behind. The law is trying to regulate the old instruments, the relations between new subjects, who are the perfect strangers to the old law. And it deals with objects, the essence of which it does not understand, and under conditions to which it is completely unadapted. The bottom line is there is a growing discrepancy between the formal existence of positive law norms regulating relations in the digital sphere and the actual absence of effective measures due to the methodological inability of traditional law to resolve conflicts with the framework of a new type of relationship. If changes don't occur, we will soon witness a universal discrediting of the status of traditional old law. It is a simple solution. The new world needs a new law, the same universal regulator, but based not on the usual social norms, morality, religion, etc., but on the fact that Dr. Tatiana Kabrieva, in one of her reports, designated as a new social regulator the program code. We can't. What will such a law look like? Part of the traditional legal system? No, absolutely not. It is definitely unreasonable to talk about the digital law as a separate branch either.
But what I'm talking about now is by no means a branch or even a new subsystem of law. We believe that this is a completely new social reality, based on a new methodology that has completely different spatial, temporal, and subject dimensions. We do not yet fully understand how this new regulatory system will coexist with traditional law, which obviously will not go anywhere and will continue to regulate current traditional legal relations for a very long time. But according to some experts, over time it is destined to become only a part of a new regulator based on fundamentally different ideas and principles. Is it so? We'll get to see. Perhaps, on the contrary, the digital environment and all its components are just a transitory civilizational phenomenon. Today, one thing is clear. The new law is already here. The most different thing is to make our conservative legal hearts accept it, realize its essence, and to learn how to work with it. Thank you all very much. Our next speaker would be the president of legal. Our next speaker is going to speak about legal policy measures of the Republic of Korea to achieve carbon neutrality.
연구 활동을 통해서 정부 입법을 지원합니다. 오늘 이렇게 러시아 극동연방대학교 제6회 태평양법 포럼에서 발제를 통해서 여러분을 만나 뵙고 한국의 법정책에 대해 소개해드릴 수 있음을 영광스럽게 생각합니다. 귀한 자리에 초대해 주시고 발제의 기회를 주신 러시아 극동연방대학교 법과대학원의 비아체슬라브 가브릴로프 원장님께 진심으로 감사드립니다. 오늘 발표에서 저는 기후변화에 대응하는 대한민국의 법 정책 중에서도 가장 최근에 작년 연말에 수립 발표한 2050 탄소 중립 추진 전략과 관련 입법 동향에 대해서 말씀드리고자 합니다. 먼저 기후변화 현황에 대한 개관과 탄소 중립 정책의 추진 배경에 대해서 설명드리고 대한민국의 2050 탄소 중립 추진 전략과 세부 과제를 소개한 후에 이와 같은 정책 이행을 위한 제도적 기반과 강화 방안과 입법 현황을 말씀드리는 것으로 마무리 짓고자 합니다. 먼저 기후변화 현황 및 탄소 중립 추진 배경입니다. 해마다 여름이면 날씨 뉴스에서 작년보다 올해가 더 덥다. 어제보다 오늘이 더 덥다. 오늘은 올 들어 가장 덥다. 라는 말을 듣게 됩니다. 왠지 매년 어른들이 그냥 하시는 말씀이겠거니 생각됩니다만 실제로 기온을 보니 지구는 계속 더워지고 있습니다. 여기 슬라이드를 보시면 1960년대와 70년대 대한민국의 평균 기온을 나타낸 표가 있습니다. 7월과 8월 최고 기온은 25도씨 또는 26도씨에 불과합니다. 올여름 한국 여름 온도가 35도씨까지 올랐다는 걸 생각하면 과연 옛날에는 실제로 덥지 않았음을 알 수 있습니다. 과학자들은 전 세계적으로 발생하고 있는 열돔 현상, 산불, 홍수와 같은 자연재해가 결국 기후변화로 인한 것이라고 설명을 합니다. 국제기후변화 패널 IPCC는 기후변화에 대응하기 위한 노력이 현 수준에 머무른다면 2050년까지 지구 평균 기온이 3.6도씨 올라갈 것이라고 경고하면서 지구 평균 기온 상승을 2도씨 이하로 유지하기 위해서는 2050년까지 2010년 기준 탄소 배출량의 최대 70%까지 줄여야 한다고 합니다. 기후변화와 우리 앞에 닥친 위기의 엄중함을 깨닫고 전 세계 197개국 나라가 2015년 프랑스 파리에 모여 지구 평균 기온 상승을 2도씨 아래에서 억제하고 1.5도씨를 넘지 않도록 노력한다는 내용의 협정을 맺었습니다. 이는 기후변화에 관한 정부 간 협의체인 IPCC가 2013년에 제5차 기후변화 평가 보고서에서 2030에서 2052년에 1.5씨 상승이 일어날 것이라고 예측한 것에 기반을 둔 내용입니다. 하지만 며칠 전인 2021년 8월 9일 IPCC는 제6차 보고서에서 1.5도씨 상승이 기존 예측에서 약 10년 빨라진 2021에서 2040년도에 일어날 것으로 예측합니다. 당장 올해부터 시작입니다. 인류 생존을 위해 탈탄소화는 이제는 더 미룰 수 없는 임무인 것입니다. 기후변화를 막고 지구의 평균 기온 상승을 억제하기 위해 유럽은 최근 유럽 그린딜 정책의 하나로 탄소 국경세, 자동차 온실가스 배출량 규제 등을 도입한 바가 있고 OECD나 UNEP 등 국제기구에서도 적극적인 온실가스 감축을 권고한 바가 있습니다. 결국 전 세계적으로 경제 구조를 바꿔서라도 신기후 체제를 이행하도록 노력해야 한다는 논리가 강조되고 있는 것으로 볼 수 있습니다. 유럽연합, 중국, 일본에 이어 미국도 2050 탄소 중립을 공동의 목표로 노력하고 있습니다. 경제 규모 세계 12위, 총 에너지 소비량 10위, 이산화탄소 배출량 세계 7위에 이르는 대한민국도 이처럼 세계적인 탄소 중립 움직임에 발맞춰서 온실가스 배출량 감축 목표를 세우고 작년 7월에는 인프라 에너지의 녹색 전환, 녹색 산업 혁신을 통해 탄소 중립을 지향하는 한국판 그린 뉴딜 정책을 발표한 바가 있습니다. 대한민국의 2050 탄소 중립을 위한 추진 전략은 이 표로 정리할 수 있겠습니다. 2050 탄소 중립을 위한 추진 전략에서 추구하는 비전이 있고 정책 방향이 있으며 각각의 정책 방향의 이행을 위한 세부 과제가 총 10가지 있습니다. 그리고 이 모든 과제의 성공적인 수행을 위해 꼭 필요한 제도적 기반 강화와 추진책의 구축이 함께 이루어져야 할 것입니다. 하나씩 설명해 드리도록 하겠습니다. 먼저 비전입니다. 2050 탄소 중립을 위한 추진 전략을 통해서 궁극적으로 목표하는 바는 능동적 대응을 통해 탄소 중립을 이루는 것입니다. 기후변화와 온실가스 감축을 논하기 이전 우리의 태도는 적응적 감축이었다면 이제부터는 능동적 대응을 도모하고자 하는 것입니다. 이는 종국에는 탄소 중립 사회로의 전환을 통해서 지속 가능한 경제 성장과 삶의 질 향상이 가능한 신경제 사회 구조 시스템을 구축해 나가는 것입니다. 이와 같은 목표를 이루기 위한 전략을 3+1로 세워두었습니다. 3은 적응, 기회, 공정이라는 키워드로, +1은 기반이라는 키워드로 정리할 수 있습니다. 경제 구조 모든 영역에서 저탄소화를 추진하고자 하는 의미로의 적응, 새로 부상하는 저탄소 산업 생태계를 구성하여 새로운 기회로 만들자는 의미의 기회, 그리고 이와 같은 탄소 중립, 온실가스 감축으로의 전환 과정에서 소외되는 계층이나 산업이 없도록 하는 의미의 공정이라는 세 가지 전략과 재정제도를 개선하고 녹색 금융을 활성화하며 기술개발 확충과 국제협력 등을 통해서 탄소 감축이 효과적으로 이행될 수 있도록 앞선 세 가지 전략을 지원하는 축을 +1로 설정하였습니다. 각각 다른 방향의 중심 정책 세 가지와 이를 지원하기 위한 한 축으로 구성된 추진 전략을 이행하기 위한 10대 과제 또한 세밀히 세워뒀습니다. 첫 번째 적응 파트에서는 에너지 전환 가속화, 고탄소 산업구조 혁신, 미래 모빌리티로의 전환, 도시 국토 저탄소화 이렇게 4가지 과제를, 두 번째 기회 파트에서는 신유망 산업의 육성, 그린 혁신 기업의 육성, 생산부터 사용 재활용까지 순환 경제의 활성화를 두고 있습니다. 세 번째 공정 파트에서는 탄소 중립 체제로 전환할 때 취약한 산업과 계층을 보호하는 한편 신산업 체제로의 편입이 가능하도록 지원하고 지자체 역량 강화, 기반 확립, 점검 체계 구축 등 단계별 지원을 통해서 지역 주도의 탄소 중립 실현이 가능하도록 계획하고 있습니다. 이렇게 경제산업계부터 시작해서 사회보장과 지원에 이르기까지 촘촘히 짜인 탄소 중립 대책에서 잘 나타나듯이 결국 탄소 중립은 한 산업이나 분야에서만 노력한다고 되는 것이 아니고 사회 전반의 변화와 실천 없이는 실현이 불가능함을 인지하고 대국민 환경 교육과 홍보를 강화하여 국민 인식을 제고해야 합니다. 이를 위해서 시민사회, 산업계, 기업 등 주체별 탄소 중립 참여를 촉진하고 전 과정에서 소통을 강화하는 것이 가장 중요하다고 하겠습니다. 이와 같은 목표와 실행 과제를 성실히 이행하기 위해서는 제도적 기반이 갖추어져야 할 것입니다. 이를 위해서 한국에서는 재정제도의 개선, 녹색 금융 활성화, R&D 확충, 그리고 국제협력이라는 4가지 대표적인 제도 기반 강화를 계획을 세워놨습니다. 재정제도 분야에서는 탄소 중립 친화성 재정 프로그램을 구축 운영하고 에너지 전환 지원이나 탄소 저감 기술 개발 등 관련 예산과 세제 지원을 강화하도록 하였습니다. 녹색 금융 활성화 부분에서는 녹색 분야 자금 지원 비중을 높이고 녹색 분야 전환 기업의 지원을 확충하였고 금융권 녹색 투자 가이드라인을 제정하는 등 민간 자금이 더욱 유입될 수 있도록 유도하고 있습니다. 그리고 기업의 환경 정보 공시 의무를 단계적으로 강화할 예정이고 시장 자율 규제 체제 정비를 통해서 책임 투자를 이끌고자 합니다. 또한 탄소 포집 활용 저장 기술 등 핵심 기술 개발을 집중적으로 지원하고 국가과학기술자문위에 탄소 중립 R&D 특위를 신설하여서 핵심 기술 분야 R&D 성과를 통합 효과적으로 지원할 수 있는 체계를 구축하고자 합니다. 마지막으로 얼마 전 P4G 정상회의 개최를 통해서 녹색 의제를 주도하고 앞으로 기후변화 선도국과 협력할 뿐만 아니라 개도국과 양자 기후변화 협정을 통해서 글로벌 녹색 동반자 연대를 구축하고자 합니다. 이 모든 정책의 법적 기반을 구축하고자 관련 입법도 진행 중에 있습니다. 현재 대한민국은 2010년 제정된 저탄소 녹색 성장 기본법을 중심으로 법률 체계를 운영 중입니다만 2020년 국회에서 기후위기 비상사태를 선언하고 정부도 함께 2050 탄소 중립을 선언한 이후 이전 법책에서 논의되던 저탄소를 넘어서 탄소 중립을 목표로 하는 법률 체계를 형성하고자 국회에서 논의를 시작하였습니다. 이에 저탄소 녹색 성장 기본법을 대체 또는 개정하기 위한 총괄 또는 기본법 성격의 법률안이 다수 제안되었고 총괄 법률 이외에도 부문별 정책을 효과적으로 추진하기 위한 각종 법률안이 제출되어 논의 중에 있습니다. 다음 슬라이드에서 보시는 다수의 법안이 현재 국회 환경노동위원회에 상정된 바 있습니다. 다만 국회는 8월 19일, 금년도 8월 19일 이 모든 내용을 총체적으로 아우르는 기후위기 대응을 위한 탄소 중립 녹색 성장 기본법을 제정하는 것으로 협의하여 곧 제정 절차가 마무리될 것으로 전망됩니다. 이와 같이 탄소 중립에 대한 정책을 총괄하는 법률안에서 가장 쟁점이 되는 사안들은 온실가스 감축 목표를 법제화하고 기후위기 대응, 탄소 중립 국가 전략의 수립, 기본계획의 수립, 이행체계를 수립하고 중앙정부와 지방자치단체의 탄소 중립 관련 계획을 수립하여 이행체계를 구축하며 현재는 대통령령에 근거를 두고 있는 2050 탄소중립위원회를 발족한 상황인데 이 위원회의 구성과 정책 거버넌스 방향을 법률로 직접 규정하고 탈탄소 사회, 지속가능 사회로의 이행, 전환을 위한 녹색경제, 녹색 사회를 구현하는 내용과 온실가스 감축 및 이행, 점검체계를 구축하는 법적 기반을 만드는 것, 그리고 탄소 중립 기후위기 대응 기금의 조성 및 운영에 관한 사항을 두고 기후위기 적응의 강화와 기후변화 영향평가에 대한 문제, 그리고 마지막으로 정의로운 전환 이행 등등에 관한 문제 등등이 쟁점으로 되어 있습니다. 탄소중립 관련 총괄법의 제정 논의와 함께 우리는 이미 국가재정법을 개정하여서 온실가스 감축 인지 제도를 도입할 법적 기반을 준비하였습니다. 올 6월 비롯된 것이라 할 수 있습니다. 기후위기의 문제는 국경을 넘어서 인류 공통의 문제고 문명에 대한 위협입니다. 각국이 탄소 중립의 목표를 가지고서 공동의 노력을 기울일 때 우리 모두가 이 위기를 함께 극복해 나갈 수 있는 것입니다. 한국은 국내 탄소 중립 정책의 수립과 이행, 법 제도화를 통해서 기후위기에 선제적으로 대응해 나가고 있습니다만 러시아처럼 그리고 우리나라와 아시아 여러 나라들처럼 무역 의존도가 높은 경제적 특징을 가지고 있는 나라는 이웃 나라와의 연대 없이는 기후위기를 해결할 수도 없고 탄소 중립 정책을 성공적으로 이행해 나갈 수도 없습니다. 그런 점에서 오늘 태평양 법제 포럼에서 이와 같은 말씀을 여러 국가의 법학자 여러분과 나누게.
Dear friends, I would now like to give the floor to my co-moderator. Distinguished colleagues, I would now like to give the floor to Deputy Head of
the Vice Chairman of Guangzhou Arbitration Commission. Firstly, I would like to express my thanks to the Arbitration Center at the Russian Union of Industrialists and Entrepreneurs, and also the Far Eastern Federal University. Thank you for inviting us to participate in the VI Pacific Law Forum. Today, I will share and make a speech on the specific measures taken by our arbitration institution for internet arbitration. And due to the COVID epidemic impact, I'm sorry that I have to give my speech online. I hope that we can have a face-to-face meeting in the near future. Arbitration is a widely accepted and important dispute settlement mechanism to resolve the trade and investment disputes in China. And we founded in 1995. We always uphold the idea of creating, sharing, and serving. We promoted the development of commerce and trade in various regions and enhanced the friendship and cooperate relations among foreigner arbitration institutions. In order to better serve the foreigner parties in South China, we offer three optional hearing models: the common law approach, the civil law approach, and mainland China style approach, which means that the parties can make their own choices to better adapt it to the legal background of themselves. And in order to expand the influence of arbitration and offer convenience to our parties, we continuously improved our service, such like exploring and developing internet arbitration, innovating the dispute resolution channel. Compared with other arbitration institutions in mainland China, and we have significant advantages in both the number of cases accepted and the quality of case handled. The number of cases accepted has ranked first among arbitration institutions in mainland China for many years. And more specifically, in last year, there are about 1,800 and 754 traditional cases and 5,052 online cases were accepted. And in this year so far, our business indicator also achieved a significant growth. In last September, now we issued the Internet Arbitration Recommended Standard, also named as the Guangzhou Standard, which created the force sharing cooperation concept and the mechanism, which including the standard sharing, hearing room sharing, arbitrator sharing, and service desk sharing. And under the guidance of the Ministry of Justice of the People's Republic of China, now we have participated in the APEC Enterprise Cross-Border Commercial Dispute Resolution Mechanism project, and we designed and polished the cross-border commercial dispute resolution online platform in this January. With a view to achieve high growth and higher requirements, we actively establishing the cooperative relations with arbitration institutions and other legal organizations and some international chamber of commerce. As of this August, we have signed memo of understanding with 114 domestic and 27 overseas arbitration institutions. This year, we have signed the MOU with International Mediation Center in Geneva and the Swiss China Law Association and some other institutions. We try our best to fill in the gap of cooperation with foreign arbitration institutions and the relevant associations. In addition, hearing room sharing and arbitrator sharing, the survey desk sharing have also been very practiced in the cooperation with other arbitration institutions and the Chamber of Commerce in China and abroad. And especially, I would like to introduce the Odr Platform. The Odr Platform published in this January, as I mentioned above, and it is a project for Chinese arbitration to demonstrate the legal service under the framework of APEC organization. The platform realized the organic connection of negotiation, mediation, and arbitration procedures, and it can track and record the whole process online. As of this August, the Odr platform has handled 98 cases, and the amount of subject matter is more than 1 billion yuan, and the average processing period is about 25 days. Recently, the Guangzhou government also issued a policy to help us build a preferred place for internet arbitration. In future, now we will continue to improve the arbitration service, and we sincerely ask all of you to put forward your valuable opinion and suggestions for our arbitration work to help us and China have a better development on the arbitration. And we also hope that through our efforts, more commercial subjects from various countries and regions will recognize Chinese arbitration service. We also welcome you to visit Guangzhou for such sitting in near future. That's all. Thank you very much.
Thank you very much for your thoughtful speech, and let me give a microphone to our next speaker. Предоставляется слово.
Now I'd like to give the floor to Doctor of Law of Academy of Law at the University and Dankook University, South Korea, Mr. Eric Jungli, who will be speaking to us online.
Good morning.
Yes, good morning. You may start. Thank you. Thank you for connecting.
Okay, thank you so much. Yeah, let me just share my presentation file here. Okay, right here. Can you watch my the presentation file, PPT file?
Yes.
Okay. Yes. Okay. So So good morning, everyone. My name is Eric Lee. I'm the professor of Jungli University and the president of Asian Institute of International Law. It is a little bit rainy here in Seoul, so I hope to be there directly, but unfortunately, due to the COVID-19 pandemic, we could not get directly there. So I hope next year we'll just get together in Vladivostok freely. So today's topic is the Usdprk peace treaty, which I suggested as a very practical measure of making peace on the Korean Peninsula. Okay, so just a moment. This reference is my article, which was published in 2 years ago in 2018 and 2019 at the Cornell International Law Journal. A few days ago, the President Moon Jae-in of South Korea just delivered his idea about the declaration of end of Korean War because more than 70 years has parties conflict. So now it's time for us to think about new peace, a fundamental peace, and the peace system in and around the Korean Peninsula. As you know well, peace treaty is the agreement concluded between the parties to an armed conflict that end the state of war or the armed conflict between these two sides. Okay, so we have to just talk about very shortly the U.S. practice, American practice about the peace treaty making. For the past nearly 250 years, the United States have signed around 18 peace treaties. So they don't, considering their interventions in the world politics and many wars, there are not many and enough peace treaties which were signed and ratified by the United States, because United States was very reluctant to make peace treaties with other countries. Okay, this is the list of peace treaties signed by United States since 1783. Okay, there are 18 or 19 peace treaties. Sometimes the two peace treaties were connected together for one enemy state. That's why numbering the peace treaty is not very accurate. But as far as concerned, 18 peace treaties were made from 1783 to 1990. The final peace treaty was made for the final settlement with respect to Germany when the two Germanys were reunified. Okay. So some people used to say the peace treaty between the United States Trump administration with the Taliban regime in Afghanistan, but it is not a peace treaty under international law because the other side, the Taliban, is not recognized by the United States government legally and officially. And the other thing is that the United States sometimes signed the mediated peace treaties, not signed mediated peace treaties, okay, like this Camp David, the Oslo, and Northern Ireland Peace Agreement and Dayton Agreement, something like that. So there are some principles when and how the United States just made peace treaties. First, the U.S. never joined the already established peace system by other powers through a peace treaty. And second, the U.S. has concluded peace treaty bilaterally rather than it being a multilateral effort. Okay, there is an exception. San Francisco Peace Treaty of 1951 which is ratified 1952. This 1951 San Francisco Peace Treaty is a multilateral peace treaty, but the United States just individually negotiate and sign with every other participant. And third, the U.S. concluded peace treaty when the concrete and practical interest for the U.S. exists in that region. We have limited time. I just jumped to the other side. You can just read my some presentation script, which would be just included in the proceedings of the conference. Okay, so there are some the historical background of Korea on Korean Peninsula between the two Koreas and between the U.S. and North Korea, between everyone. But the problem is that the U.S. and North Korea, they just wanted bilateral some peace treaty, not comprehensive peace treaty. Okay, this is a U.S. state practice for the past 250 years. That's the problem. Okay, so 1954 Geneva Peace Conference. Okay, and in 1994, because in order to just resolve the nuclear weapons crisis, of North Korea, the U.S. and DPRK got together to sign the Geneva Agreed Framework, exchanging the energy provision and denuclearization, and then another agreement was made between the two sides, through the 6 parties top frames. So in practical conditions, okay. So political environment, U.S. strategy is that the United States changed its strategy considerations and perspective. Since the late 1990s, U.S. has gradually shifted its strategic stance toward North Korea from the Clinton administration. And then, unfortunately, it was just rolled back again by the Bush administration when the President Bush declared North Korea as one of the axis of evils with Iran and Iraq. Okay, what we have to think about here is that it's fundamental. It is a very important and critical question: is fundamental regime change of North Korea virtually possible? So President Trump and President Bush, they were considering even a military intervention in order to dismantle North Korea's regime, but actually it was virtually impossible because of some close alliance with China, and actually at that time, the Trump administration should have recognized that North Korea is not similar to the 1990s former Eastern European bloc states who collapsed like dominoes following the dissolution of the Soviet Union at the time. But China is backing up North Korea because both share the same security interest in this region. This is a very highly critical point and issue that we have to consider while just thinking of this kind of situation. Okay. Okay. So, and then the United States from Trump administration shifted its stance towards DPRK, North Korea, into the bilateral approach instead of multilateral, so bilateral. So North Korea is willing to consult with US, and US also just willing to consult with North Korea. So there were several summits, a few summits between US President Trump and the chairman Kim Jong-un, but until today, there was no concrete some result from their some summit. Okay. Yeah. So considering U.S. practice, the USDPRK peace treaty will be the key to peacemaking in the Korean Peninsula as well as in Northeast Asia. Such peace treaty will be also a turning point of U.S.-China relations, and also, of course, the U.S.-Russia and U.S. DPRK, of course. Okay, because the Korean Peninsula is in the very some bridging point of whole Northeast Asian some forum. The United States does not want to recognize the changing status quo of the regional politics. Yeah, since the end of Cold War, the San Francisco system, I mean, just based on San Francisco, the peace treaty of 1952 has not been fully operational. The rise of China is a critical factor that restricts American hegemony in East Asia. North Korea is manipulating this power vacuum with its nuclear weapons development program. The DPRK peace treaty means not just the normalization of bilateral relations, but more fundamentally, the recognition of China as an equal partner in the Asia-Pacific region, which has never been imagined by the United States. Because the main strategical point of view of the United States is that the United States has not accepted any challenger on the earth since the end of Cold War. Therefore, the peace treaty is not only an agreement to officially terminate the Korean War, but it is a constitution for a peace regime in this region, which is the ultimate concern of people. It can be first established between the US and North Korea bilaterally, and then exist as a comprehensive formula. South Korea could be a mediator in this process. So we have limited time, so I could not just handle all my ideas just embedded in this presentation. But you can just read my ideas in the subscript. And okay, here. So I drafted an agreement between the United States of America and just the Democratic People's Republic of Korea on the 1953 armistice, denuclearization, and rapprochement. Okay, so I think my actual presentation should be finish it here. Okay, and then. I would like to have
Managing partner of Savina Legal Advocates.
Good afternoon, dear colleagues. The topics which are discussed here are very deep, and they relate to globalization trends, and the influence of law on globalization is multidimensional. And it is very interesting for me to listen to speakers which I liked specifically, which was given by Dr. Kurilov, that the law is lagging behind. But the globalization focus is focused on deepening the legal relations between the countries, between the businesses, between individuals or economic sectors, and their interdependence and their interconnection as actors in this process is very important. Well, there is a definition of globalization nowadays shared by many experts, which view globalization and the law development as the continuation of globalization. But when we talk about globalization, we talk about the mergers and acquisition of enterprises, of processes of various individual components into one global system. Results in integration. Some scientists see the dependence that integration is the continuation of globalization, because globalization only puts accents on key factors for international cooperation, and then those linkages between individual elements of or subjects of cooperation adjust to it. And I think this, I would agree with that. Today we are witnessing how the tendencies are increasing in the field of globalization in the form of technological revolution, concentration and centralization of capitals, integration of international business, liberalization of the world economy, widening of the and growing influence of international institutions, and increasing the challenge, the number of acute problems and transformation of political systems which influence on international and national landscape of the countries, intercultural cooperation. And the main feature of globalization is that it represents the qualitative transfer of relations between the countries, which is characterized with the very high interdependence in various economic and social relations. It's a multi-layer, which touches culture, economics, ideology, technological process, and influences the whole global development and individual in particular. The legal problems arise under the implementation of this process, which deal with the social economic relationship, and the international law continues to play a more important role as a balance of international law and order. The generally accepted rules and regulations of international law coincide with national interests of particular states, such as sovereignty, and sovereignty of national security and constitution. It has, and it also deals with the rule of law and represent the institutional preconditions for establishing international international order. So international rules and regulations govern the constitutional priorities of governing principles in the Constitution, such as the human rights as the highest priority for these for the state development, an equal approach and equal and all international levels with regard to human rights protection view the rule of law as a key factor for ensuring the human rights paradigm. And it applies to all the states. Our country is not as an exception. We cannot be excluded from the global processes, but other countries have to cooperate in this field to strengthen the international law and its position. As Article 4 of the Russian Constitution applies, clearly state that Russian Federation are based on general international laws adopted and signed by the Russian Federation, and it is demonstrated by the civil code, which was heavily influenced by Convention of UN on sales and on goods, And hard currency control law of the Russian Federation is based on the International Monetary Fund guidelines for hard currency hard currency operations. When we talk about the legal regulation, we are lagging behind, and sometimes we reject those international rules which we feel that do not meet our requirements. Our legal system is very slowly integrated into this process, and we are not really ready at this point to be adaptive as it is required. So the courts, the role of the courts as a protection legal mechanism is becoming more and more important. It has been changing since the process of globalization started. First of all, the use of the national law and international rule and international legislation when we solve various international disputes. And we need to change the focus and adopt the trend for the international laws to govern national legislation in many areas which are universal. As far as the creation of new norms, it also deals with the functioning of the court system. We have the Supreme Court, we have the Constitutional Court, but the legal practice should be developing more active. We are witnessing that the Constitutional Court of the Russian Federation is becoming more and more active in the formation of new legislation. In our court practice, we are based. We more often rely on the legal practice of other courts on the national scale and the international scale, and this serves as a trigger for new transformation of the court system and to apply international rules and legal approaches within the national legal practice. We started to use as a practitioner, as an attorney. I would like to give you an example of my personal experience, which is quite. It is a good example at the ground level, on the grassroots level, dealing with the dispute between two business entities, and but this example clearly shows how we are in the Russian Federation are using the experience which we gain from the international legal practice by using the system take or pay approach. I was defending the case in the Supreme Court of Russia with regard to the forwarding of the call in court based on the Russian legal precedent. But then the case was reviewed by the Supreme Court of Russia, and although the take or pay hasn't been incorporated as a legal principle to the full extent in the Russian legislation, but based on the practical based on the practical experience, this principle was protected by the Supreme Court of Russia for the Russian business entity, and the take-or-pay approach won the case. But it influences all those influences transformation, micro regional level. It helps, globalization helps to make the legal system more universal and changes the nature and the meaning of the law, but also the sources and the forms of law. Also changes the legal regulation mechanisms, international relations arrangements, and the global processes are inevitable, and we are going to continue to face and deal with them in the nearest future, and we need to be to work in hand with the international community. And I think that the Russian state has to find the optimum balance between the flexibility of political course pursued by the government and the will to become the active stakeholder in the globalization, at the same time retaining its national identity, a legal, and keeping integrity of national legislation, but at the same time not to find ourselves in a position when the law is lagging behind. So we need to consider the globalization trends in our national and international legislation endeavors. Thank you very much. Thank you, Olga. I would like to give a floor to Professor Alexander Grybelsky from the Department of Private International Civil Law at the Moscow State Institute of International Relations, the managing partner at Grybelsky and Partners Law firm, and the member of the Mediation Center of the Russian Entrepreneurs. Mr. Grybelsky, the floor is yours.
Good afternoon, dear colleagues. I'm excited to welcome you all on behalf of Arbitration Center at the Russian Council of Entrepreneurs and Industrialists. I'm excited to share some of my insights about arbitration, specifically about arbitration as a way of eliminating of made contradictions in the changing world. Here I would like to say that unlike other negative impacts of globalization and other changes, and those things that are being voiced in the title of the forum, international arbitration is a positive result of globalization. Arbitration is sort of globalization par excellence, and that's true. This mechanism is a more preferred way of dealing by most of global companies, because arbitration brings parties and arbitrators from different parts of the world. Their participation in the process allows to fill the disputes with different arbitration traditions, because this is a way of how a vast way of globalization of law, and all research that were conducted by our university and St. Mary's University, Untitled, are telling us about the growth of popularity of both commercial and investment arbitration. I would allow to briefly remind you. So in most of cases, international arbitration is a neutral procedure which avoids using national regulations, which is adapted to the requirements of each party with consideration of what they would want. Arbitration could adapt to different situation, unlike the requirements of the global world. And here we see observe main principles such as due process. Parties are promised an equal treatment, an ability to be heard, an opportunity to be heard. But this procedure is relatively quick, and the decision is fundamental, and its recognition in the third countries is assured by two super popular conventions: the New York Convention of 1958 and the Washington Convention, New York and Washington Convention. All of these are manifestations of the idea of superiority of law, which the parties of the dispute rarely think about. And a good example of this is the situation that occurred during pandemic, when arbitration became the only vital mechanism of addressing transboundary disputes. Having confronted the limitations that we have seen caused by coronavirus, participants of arbitration institutions which administer this decided to look for new ways of adapting the new procedures, which is disrupted by freedom of movement and the need for social distancing. All of this imposed limitations. Multiple parties were not able to participate in the oral discussions personally, which made this discussion difficult. Such as getting the final verdicts. Most of the arbitration institutions have taken efforts to make sure that discussions could be started, and many institutions have preserved their unity of addressing, and that reminded the arbiters to use online platforms, and the result, arbitrators around the world have adapted to the new reality. And unlike the national states, arbitrators around the world, for example, arbitration center at our arbitration centers, a whole have reviewed the disputes by means of online conferencing. And throughout this time, over 160 disputes were considered, including 4 global, very well-known international disputes with participation of arbitrators from around the world. But the advantages of arbitrations are used not only by entrepreneurs, but we came to realize that arbitration became a useful mechanism to address not only business disputes, but also interstate, intergovernmental disputes. In Hague, they have created a arbitration of 1899 during the first Hague peace conference, which was initiated by Nicholas II, the Tsar, the King of Russia. No matter how surprising this might seem now, unlike the opinions of multiple European sovereign states, it was supported by the United States, and the conference that was started on the 18th of May became actually the reason to start an opera titled Arbitration. The name of a person who has done so much for the arbitration movement that the judge would replace the soldier should be proclaimed from one part of the world to the other parts of the world as a leader of global progress. And in fact, the wars that were held, that were seen during this first arbitration, have became known as a tool that actually made suffer both attackers and defenders, while arbitration became a very useful tool for all parties. A good example of contribution of arbitration to the peace movement was the fact that now we see, such as gunboat diplomacy, when the interest on international entrepreneurs were defended by their states. Such mechanism is investment arbitration, which, no matter what sort of disadvantages it has, which are still being found until today by conservative legal scholars, it still makes a contribution to the development of the law. And it's important to say that recipient states of international investments, which confronts the difficulties of verdicts that are given against them, they still need to advance to address the disadvantages that were put into different disputes. There's no, as of now, replacement for international arbitration, which is why the Russian Federation, in the framework of its work in UN Central, cannot find a replacement for it. And of course, arbitration can address other challenges of modernity. Arbitration is used in energy disputes. However, very few people would know that arbitration could serve a mechanism to address the climate disputes, especially those that emerge during using of UN Convention on Change of Climate and Paris Accords, climate accords. Now, some working groups in multiple arbitration council in Paris and Stockholm had their research and demonstrated findings on how arbitration could be used for addressing the climate change. It's a known fact that arbitration is is an older tool that can be used, unlike the state judiciary. I suggest all of you to use arbitration. Thank you all very much.
Thank you very much, Dr. Grybelski, for finding the time to participate in online on regime with our forum. We have another report by Dr. Niznamov, and he was supposed to come and join us for his presentation. He was delivering the lecture to students. Is he coming to join us? Yes, he's approaching our conference hall. What will be your suggestion, Dr. Gavrilov? Dear colleagues, this Mr. Niznamov, he is the executive director for governing artificial intelligence for Sberbank, and he is the member of the European Union Committee for Artificial Intelligence Development. He is in charge of educational programs with regard to AI and he came up with initiative to deliver a report in our forum with regard to what is going on, what is the situation with artificial intelligence. How are we going to do? Maybe we should first start signing the memorandum of understanding and then continue with the presentation. One of our signing party left the conference room as well. So, dear colleagues, if you have, I would like to encourage you to ask some questions to the speakers. We didn't expect this in our. We didn't include Q&A session in our program, but anyway, are there any volunteers to ask some questions to the speakers of the plenary session? I have a question. We are here gathered in Far Eastern Federal University, and how this all is going to influence students, all these changes which we are talking about. We are talking about the problems and challenges, trends, how it's going to impact the educational process. Is this question which you would like me to answer? Yes, because you are the host of this session and you are the dean of Far Eastern Federal University Law School. If please, would you be so pleased to highlight and to dwell on that? You are absolutely right. I think I can identify two major trends influencing, which will govern our discussions today. The content of education from the subjective point, from the subject's point of view. We need to attract giant, big companies, practitioners, in order to understand what kind of specialists we are training and where are they going to work, with regard, of course, within the scope of state standards. We need to make our legal education more focused on the demands of the business entities, and for the graduates it will be more clear where are they going to work after graduation from the university. Our legal education should become more specialized, more specific. In those endeavors, we hope that our business partners will support us and join us. The second thing is the methodology of teaching, the new teaching aids, the new trends in training, in providing education will be in demand. The use of various electronic tools, gadgets, the operation and access to the mass of information which was not even imaginable to be accessed earlier. So we are facing big challenges because we need to process this information. So there are two trends. Whom are we going to? What specialties we are going to teach, and what and whom, and what methods in teaching we are going to implement. I would like to give a floor to Dr.-in-law, who is the director in governing AI of Sberbank, and he is the head of the working intergovernmental group on artificial intelligence, Dr. Andrei Niznamov. Good afternoon, dear colleagues. I would like to talk about the regulation of and ethical issues with regard to artificial intelligence. I'm representing not only Sberbank, but also the Russian scientific community, which deals with the development of artificial intelligence in Russia. If you had a chance to listen to my lectures, I usually start my lecture with this picture. In 1865, when first automobiles appeared, everybody was scared of the new automotive vehicles. So under this law, a man with a red flag marching in front of the automotive cars was a requirement, and which now we are dealing with it, breakthrough new technology, artificial intelligence. How we are going to manage it? We were in the beginning of this century. It has become clear that it is very important. The scientific magazine Nature has published the study on the ethics of artificial intelligence approaches pursued by many countries. There are several major principles of legal regulation of artificial intelligence in the world. As a lawyer, and I am delivering my report in front of the future lawyers, we are talking about, first of all, about putting at the first place moral and ethics rather than legal norms. More than half of various proposals was delivered by NGOs and private groups of researchers, like and you can see this example on the screen. Then, driven by the technological progress, corporation norms started to govern. More than 30 tech giants of the world has adopted their ethics AI codes. First of all, 10 laws for artificial intelligence by Microsoft, and then Google. It was joined by Google, by other stakeholders, and of course, Sberbank of Russia also joined this team. I would like to bring your attention to several national initiatives related to AI ethics pursued by by various states. It's a part of the soft law approach, which means that without creating special legal norms, the state encourages the use of artificial intelligence ethics. Look at the Great Britain. Several institutions started in Great Britain to support this policy, as well as other countries like AI ethics framework in Australia, or social principle of human-centric AI in Japan. Then subnational initiatives and UNICEF in December, UNICEF will adopt the first ethics guidelines. I'm going to talk about Russia. In 2019, when President of Russia has adopted the national strategy for AI development, it was clearly stated the AI ethics should govern all the endeavors. In 2020, the government once again supported this policy and alliance in the sphere of AI, joined by the representatives of the government and major, have received many proposals from Forest and Federal University, from legal experts and students, which allowed us to close the gap in these studies. And I would like to thank once again, dear colleagues, that we are discussing this new technological reality in which, and would like to advocate and support your future breakthrough, your future participation in discussion and studying these new breakthrough technologies. Thank you very much for the opportunity to deliver this presentation in our forum. I hope that, and I'm absolutely sure that we will have volunteers and those who will be joining your work. Now it's time for us to start signing it's time for signing the joint signing of memorandum of understanding between Service Center FESCO LLC and Savina Legal LLC and Forest and Federal University. I would like signature parties to come to the podium and sign. But I also would like to give.
So this company provides consulting companies to 2,500 employees through 11 major areas of development. That is accounting, document movement, accountancy, legal support, expertise, economy and planning, IT, management of effectiveness, administrative services. So, Service Center of FESCO is a one-stop shop for a FESCO company. Savina Legal is confidently developing legal company which brings together lawyers, arbitrators. Major companies' function is restructuring and bankruptcies, addressing legal disputes, and protection of the interests of the clients in negotiations and legal disputes. So we're now signing a three-party agreement, and the third party is a well-known Far Eastern Federal University. Dear colleagues, at this point, our plenary session comes to an end. And now I'd like to suggest you to take a joint photo as a background of the logo of our large banner. And after that, at 2:30, we will have breakout conferences based on the conference of the program. You all have that in QR codes and have an electronic program, and it's all printed. There's also navigation throughout the university map, like, finding. So you can always ask the volunteers, and it will always share you with the information. So we're inviting everybody to take photo.
Пойдемте сфотографируемся. Володя, Green Energy.
Наталья Геннадьевна, а где тут баннер-то самый? Вот этот баннер или какой? На фоне большого.